All right. Hey, Vikings, welcome in. Thank you for being here. I appreciate it. Okay, now's the time where we're going to talk about each of the 15 required Supreme Court cases. I'm going to review all of them. And of course, if you have any questions, don't hesitate to ask me. You can't ask now during the video, but you can comment below. You can send me an email. So here's just a list of all 15. I didn't number them because we don't need to have numbers for the cases and we don't need to align them like that, like we do amendments. And you don't necessarily need to know the years that they were decided, but it is important because it just does give you a little bit of a context of what time in history or what time of the country were we in when that happened. This is basically just a copy and paste of what comes out of the curriculum. So the curriculum for AP Government identified 15 required Supreme Court cases, which was nice because it used to be over 100 cases that we would be expected to teach students. So they went ahead and identified 15 as the most important. But because they identified these 15, there's a higher expectation of knowledge and understanding around these cases. So everything, all the words here that you're seeing, these are basically just pulled from the curriculum. This is what the AP Government class has identified as this is what you need to know about this case and why it's important. So why do you need to know these cases? These landmark cases, like I said, they've been selected by College Board to be featured on the AP exam. Most of them deal with a specific topic or key term that we need to understand. And so you're going to encounter these questions, you're going to encounter questions about these cases and their impacts in the multiple choice section. Also, question 3 of the FRQ portion, the free response portion, will be what we call a SCOTUS comparison. When we say SCOTUS, we're referring to the Supreme Court of the United States. So that's just an abbreviation. But number 3, the third question on the exam, is basically a comparison where you're going to be reading about another case that's maybe related to one of these 15 cases, but you've never heard it before, likely. You're going to read the facts on that case, and then they're going to ask you questions about how it relates to one of the required cases that we have, basically. So you're going to be expected to describe the facts of each of the cases and then explain any similarities or differences between the two. So what do you need to know about these required cases then? You need to know the people or groups that were involved in each case, the plaintiff and the defendants, the facts and issues that led to this needing to be resolved by the Supreme Court. So how did this case get to the Supreme Court? A basic description of the federal constitutional question. What was the court trying to answer? What were they trying to solve, basically? And then you should also know the outcome and significance. What was the ruling of the Supreme Court and what's the impact on us today? So each of these cases is under an enduring understanding, basically. And some enduring understandings have multiple cases. Some enduring understandings only have one case. This is an example of just one case. So the enduring understanding here is the design of the judicial branch protects the Supreme Court's independence as a branch of government, and the emergence and use of judicial review remains a powerful judicial practice. Judicial review, please remember, is the power of the courts to overturn actions of the president, actions of Congress, actions of the states. And if those actions are unconstitutional, the court can strike them down, basically. So our first case we're going to look at is the most important case. It's Marbury versus Madison, which established the principle of judicial review, empowering the Supreme Court to nullify an act of the legislative or executive branch that violates the Constitution. So if either of the other two branches or the states are violating the Constitution, the Supreme Court can rule on that and put an end to their actions. Okay, so we already just read the enduring understanding, or the key takeaway, I should say. The facts around this case, basically this was like a minor paperwork issue. You had Marbury, who basically wanted a job, and he was appointed by President Adams and he was confirmed by the Senate. But this was very last minute, and it was done basically as a way to address the anti-federalists and their winning of the elections. And it basically was an attempt of the Federalists to try to take control of the federal courts, basically. So John Adams, in the late hours, in the last minutes of his presidency, is nominating judges, and they're getting confirmed by the Senate. And Marbury was one of those judges. So he'd been appointed to be a justice of the peace in the District of Columbia, but his commission was not delivered. So there was a piece of paper that Marbury didn't get that said that he was going to be a judge. So commission is basically just, the piece of paper that says, yes, you have the commission or you're being asked to be a judge. So because Marbury didn't get that piece of paper, he was not able to take his new job. So Marbury petitioned to the Supreme Court. They said, Supreme Court, you should force James Madison to deliver these documents. So Madison didn't want to deliver the documents because Madison was feeling like, I don't want this person to become a judge. And if he doesn't have this document, then I'm going to prevent him from doing so, basically. Marshall was in a really tough spot. And by Marshall, sorry, I mean a Justice Marshall, Chief Justice Marshall, who was the decider, the author of this opinion, basically. So what did Marshall want to do? Marshall was a Federalist. He truly wanted to give Marbury the job, but recognized that if he had made a ruling that forced Madison or forced President Jefferson to turn over and deliver a commission, that they could just refuse. And that would make the court look weak. So Justice Marshall basically comes up with a genius plan to reject Marbury and make Madison and Jefferson feel like they're getting a win, but then also to establish this awesome power of judicial review. So the issues in the case were, do the plaintiffs have the right to receive their commissions? Was Marbury wronged? Can they sue for their commissions in court? And does the Supreme Court have the authority to order the delivery of those commissions? So on the first two questions, Marbury wins. He said he did have a right to receive the commission and that he does have a right to sue, but the law that he was suing under, they said was unconstitutional because it gave the courts too much of a power that would violate the Constitution. So basically, Justice Marshall says, actually, we can't give you a ruling here. We can't force these other people to basically deliver your commission because we don't have the authority to. And the law that created that is actually unconstitutional. So Marbury, you don't get a job, and we're sorry about that because you probably did deserve it. Oh, and by the way, we also now have judicial review. So I would say, the facts around this, it's like I said, it's a minor paperwork issue. I think the most important thing to know is the outcome. That the Supreme Court struck down the Judiciary Act of 1789, and by doing so, established the power of judicial review. Justice Marshall basically said that the Constitution is law, and it's the judge's job to interpret the law. So that means that it's their job to interpret the Constitution. So important to remember that judicial review is not expressed clearly in the Constitution. The words just aren't there. This power was established in this Supreme Court case by the courts, basically. So they kind of established their own check on the other branches. But without this, the courts would have no way to check the other branches. So this is an important check. It's an important power of the courts. And it's really their only power to make sure that the other two branches are actually following the Constitution. Check out the video on Marbury versus Madison. It's from the Bill of Rights Institute, and it's a really awesome just overview of all the key parts of that case. Okay, we're on to our next enduring understanding. Federalism reflects the dynamic distribution of power between national and state governments. So we have two cases that relate to federalism. One is about basically expanding the federal government's authority, and the other is about limiting the federal government's authority. And that's a common theme that you'll see in these Supreme Court cases. The reason is because the AP test wants to be able for you to be able to provide examples of each, basically, of a time when federal government was expanded and a time when federal government was limited, basically. So this enduring understanding is all about federalism, that it reflects the dynamic distribution of power between the national and state governments. So we're going to look at McCulloch v. Maryland and also U.S. v. Lopez within this enduring understanding. So McCulloch v. Maryland established supremacy of the U.S. Constitution and federal laws over state laws. Basically, this case was all about the United States government establishing a bank in the state of Maryland. So a federal bank was established in the state of Maryland, and Maryland didn't much care for that. They didn't like the bank, so they decided to tax the bank and basically said that the bank would be forced to pay a tax to the state of Maryland for existing within its state. But McCulloch was basically someone who worked at the register, and he refused to pay the tax. So when someone from Maryland shows up, McCulloch says, we're not going to pay this tax. We're the federal government, and we're supreme over the state, so we don't have to pay it, basically. So Maryland sued the U.S. government. And there were two questions that the courts were looking at. First, does the federal government even have the authority to establish a bank? And then two, Is the federal government supreme over the state governments, basically? Then is it okay for Maryland to tax such a bank? So Maryland's going to lose on both of these questions. Yes, the federal government does have the authority to establish a bank. Why? Because of the powers of the elastic clause powers in the necessary and proper clause that allows Congress to expand their powers. They said that establishing a bank, even though it was an enumerated power, it is an implied power and connected and related to other enumerated powers around coining money, around collecting taxes. And then the second question, is the federal government supreme over the state governments? Yes, it is. In the Constitution, we have something called the Supremacy Clause, which says the federal government and the laws of the federal government are supreme over the states, basically. So the decision was that Congress can establish a national bank under the necessary and proper clause, and that states cannot tax the federal government based on the Supremacy Clause. Basically, Justice Marshall said the power to tax is the power to destroy. And so he didn't want to give the authority to state governments, giving them ability to tax the federal government, essentially. So can the federal government tax the states? Yes, they can, because states gave the federal government that power in the Constitution. But states don't have the power to do the opposite. So states don't have the power to tax the federal government. In this case, just reinforced that and upheld that, basically. So I call this one the bank case. I've got a visual for each of these so you can try to remember. I call this the bank case, and it's basically like, can Congress establish a bank and can Maryland tax it? Yes, they can, and no, they can't, basically. That's the main answers around that. So check out the Bill of Rights Institute video on McCulloch v. Maryland. Okay, so what's the other case relating to federalism? This is U.S. v. Lopez, which said that Congress may not use the Commerce Clause to make possession of a gun in a school zone a federal crime. So what are the facts around this case? Basically, Congress passed a federal law called the Gun-Free School Zones Act. And it basically said that you couldn't carry a gun within, 150 feet of a school, basically. Now, Alfonso Lopez is a high school student, and he brought his gun to high school. He was charged under federal law. But Lopez's lawyer basically made the argument that this federal law shouldn't exist because it's actually a state area that should be regulated by the states and local governments and not the federal governments. So the question there was, does Congress have the authority under the Commerce Clause to pass federal law regulating guns in schools? Because there's nothing in the Constitution that allows, like in our enumerated powers, there's nothing that says to regulate schools or guns. So how did Congress pass this law in the first place? Their justification was, they said, well, schools, educate students, and then they become members of economic society. And if they're fearing guns in schools, it might affect their school performance, and that's going to affect future economic activity, basically. The court didn't buy that argument, and they basically just said that Congress was exceeding its authority and doing too much under the Commerce Clause. From like the 1930s up until the 1995, Congress was really allowed to use the Commerce Clause, kind of a blank check to write whatever laws that they wanted to. They would just always connect it back to business. So this limited Congress's Commerce Clause powers. It struck down the Gun-Free School Zones Act because basically they wanted to ensure that states and local governments would be regulating that behavior. So is having a Gun-Free School Zones Act illegal? Well, it just can't be a federal law, but many states do have laws around, where you can carry guns around school zones and stuff like that. So basically, creates a federal system that protects state power. And also the court ruled that the Commerce Clause does not give Congress endless power as they've been using up until, from the 1930s, basically. We're saying like Great Depression era up until 1995. Okay, so U.S. v. Lopez, I've got a really great video. I recommend you go back to lecture and check that out. It's the Bill of Rights series on homework help. It's really awesome. And there they are right there. All right, okay. Now we have an enduring understanding, and this has got the most cases under it. These cases we learned in Unit 3 when we talked about civil rights and civil liberties. Enduring understanding is provisions of the U.S. Constitution's Bill of Rights are continually being interpreted to balance the power of the federal government and the civil liberties of individuals. So we've got a lot of cases, 5 cases that relate to these. Basically, what are our civil liberties and the interpretation of those liberties, basically. Engel versus Vitale and Wisconsin v. Yoder are cases that deal with freedom of religion. Tinker versus Des Moines and Schenck v. United States are cases that deal with free speech. And New York Times Co. versus United States deals with freedom of the press. So these are all basically First Amendment cases and the interpretations of those. Remember, the First Amendment has several protections. So Engel versus Vitale, case relating to freedom of religion, basically said that school sponsorship of religious activities violates the Establishment Clause. Remember, the Establishment Clause is the part of the First Amendment that says that Congress cannot establish a national religion. So the New York State Board of Regents authorized a short voluntary prayer to be recited at the start of each school day. And a group of organizations joined forces to challenge the prayer, claiming that it violated the Establishment Clause of the First Amendment. And the New York Court of Appeals actually rejected their arguments. So then it was appealed to the Supreme Court. The issue was, does the reading of a non-denominational prayer at the start of the school day violate the Establishment of Religion Clause of the First Amendment? And the Supreme Court basically upheld the Establishment Clause and basically upheld this idea of separation of church and state. So it said that the state cannot hold prayers in public schools, even if the participation is not required, and even if the prayer is not tied to a particular religion, basically. So this is the case that basically said that, public schools, I'm talking about specifically public schools, because they're part of the government, or they get their authority or delegation from the government, do have a responsibility to uphold this idea of not establishing or endorsing a religion. And so in this court case, they basically said that, school prayer, even if it's voluntary, even if it's not tied to a particular religion, still violates the Establishment Clause, basically. So my way of remembering this, it's important, especially with these cases where you just have two names of individuals, to come up with ways to remember these cases. One student told me that the word Engel kind of looks like angel. And so that reminded them that this was a religious case. And then another student told me that it's vital that you not be forced to pray in school. And they come up with that saying, basically. So it's Engel versus Vitale are the names, but you don't need to know those, how to pronounce them. It's important to just know that this case related to school sponsorship of religious activity. It violates the Establishment Clause. So no required school prayer. Got a great video on that. That's a teacher explaining what we need to know about Engel versus Vitale. Okay, another case relating to freedom of religion. So we're still in the First Amendment. And this focuses on the Free Exercise Clause. So the first part of the First Amendment says Congress cannot establish a religion. And then the second part of the First Amendment basically says that they cannot prohibit the free exercise of your religion. So if you've got religious practices or things that you like to do for your religion or forced to do for your religion, that the government cannot ban that practice unless they have a compelling state interest, basically. Usually health and safety would be considered okay and compelling. So who are the Yoders? The Yoders were an Amish family. And in the Amish community, they don't believe in use of electricity, and they also live in very tight-knit communities. And so the Amish family, the Yoders, didn't want their kids being forced to go to school past the 8th grade. But Wisconsin had a state law requiring that. So you had Jonas Yoder and Wallace Miller, both members of this Amish religion, who were prosecuted under this Wisconsin law that required all children to attend public schools until age 16. But the three parents refused to send their children because they said that, after the 8th grade, arguing that high school attendance was contrary to their religious beliefs. They were worried about the things that their kids would be exposed to being forced to go to high school. So the question was, did the Wisconsin's requirement that all parents send children to the school at least until the age of 16 violate the First Amendment by criminalizing the conduct of parents who refused to send their children to school for religious reasons? And the court ruled in favor of the Yoders. They basically said that individuals' interests in the free exercise of religion under the First Amendment outweighed the state's interest in compelling the attendance beyond 8th grade, basically. So in this case, the Yoders win, and they're not forced to send their kids to high school past 8th grade, basically, that they can do their own type of homeschool education, basically. So the Yoders are going to win this one, and this is also a case that relates to free exercise, that you get to freely exercise your religion. And the states, again, are not allowed to ban a religious practice unless it's harmful. If it's harmful to society or if it's a safety threat, then it's okay, because that's considered a compelling state interest. Okay, now we're talking about some of my favorite kids, the Tinker kids. This one's Tinker v. Des Moines Independent Community School District. So this is a great case because it has a really good context clue. An independent community school district. Now you know this is a case that relates to a school district. And who are the Tinkers? They were kids I remember, don't tinker with my rights is what students will sometimes say. But basically, the ruling on this was that public school students have the right to wear black armbands in school to protest the Vietnam War. So the facts around this case is you had some students, the Tinkers and a friend of theirs, that were suspended at school for wearing black armbands that had the peace symbol on it. And they were wearing it to protest the Vietnam War. You can see the Tinker kids right there. And now the students they were suspended. They could have accepted their suspension and served their time and then gone back to school, but they decided to challenge the ruling, basically. And they challenged the suspension for violation of the First Amendment freedom of speech. So the issue in the case was, does prohibition against the wearing of armbands in public school as a form of symbolic protest violate the students' freedom of speech protections guaranteed by the First Amendment? This is a very important and significant case because this was the first time the courts actually recognized that students have some rights in schools. Now, you don't have complete and absolute right to free speech in school. Absolutely, we can restrict or regulate that if it's disruptive to the class environment, basically. So if you're just engaging in a protest by wearing an armband or wearing a t-shirt, that's perfectly okay. And that's a way to express yourself and your political beliefs. And that as long as it's not disruptive or distracting to the class environment and the learning process, then it's perfectly okay, basically. So the Supreme Court said, yes, the Supreme Court held that armbands represented pure speech that's entirely separate from the actions and conduct of those participating in it. So the court also held that the students don't give up their First Amendment rights to free speech when they step onto school property. And that, also they recognize that kids need to learn about their rights. And so what better way than to recognize some of the rights that they do have in school? So do you have a right to free speech in school? Yes, but it can be limited. If you're disrupting the educational process, then that definitely is something that can be regulated by the school administrators, basically. But you just wearing a t-shirt or an armband to protest something, that's perfectly okay, and that should be upheld. Okay, so a great video on the Tinker Kids from the Bill of Rights Institute. Check it out. All right. New York Times Co. versus United States. Another context clue in the case. You should know the New York Times Co. is a newspaper organization. This bolstered the freedom of the press, establishing a heavy presumption against prior restraint, even in cases involving national security. This case is also known as the Pentagon Papers case. The Pentagon Papers were these secret government documents where they tried to study the Vietnam War and understand the causes of it and then the reasons why we still are in the Vietnam War. And so this document that was developed by the Pentagon made the government look so poor that they decided not to publish it and let the American people know about it. But Daniel Ellsberg, one of the chief authors of the document, was upset by that. And he felt that people needed to know this. He was an anti-war advocate. And he felt like part of the reasons that we're still staying in the war is because people don't have a full understanding of why we got into the war and that the American government was still lying to the people. So, Nixon administration tried to prevent the New York Times and Washington Post from publishing the materials because what Ellsberg did is he went and took those papers and handed them to the New York Times, and they had to make a decision whether or not to print. And when they were stopped from doing so, then the Washington Post also had to make that decision. So basically, it was an attempt to stop the publishing of materials belonging to a classified Defense Department study regarding the history of U.S. activities in Vietnam. And the president argued that prior restraint was necessary to protect national security. Prior restraint is basically censorship. And in this country, we don't allow prior restraint. And the Supreme Court upheld that, having a heavy presumption against prior restraint, that we don't tell newspapers what to print in this country. Unlike in other countries, that is allowed. So the question was, did the Nixon administration's efforts to prevent publication of what they termed classified information violate the First Amendment? And the Supreme Court said yes, that the court held the government did not overcome the heavy presumption against prior restraint in this case. And Justices Black and Douglas argued that the vague word of security should not be used to try to, take away the rights protected by the press under the First Amendment. I've got a really great History Channel video that I recommend you check out. It's just basically a history of the Pentagon Papers and then the Supreme Court case that related to that. This is our only case really dealing with the media. Okay, Schenck versus United States, another case involving speech. Speech creating a clear and present danger is not protected by the First Amendment. So the case, you pronounce it with as Schenck. It looks like Schneck, but it's Schenck versus United States. During World War I, you had a socialist, Charles Schenck, and he distributed leaflets declaring that the draft violated the 13th Amendment, prohibition against involuntary servitude. The leaflets urged the public to disobey the draft, but advised only peaceful action. Schenck was charged with conspiracy to violate the Espionage Act of 1917 by attempting to cause insubordination in the military and obstruct recruitment. Schenck was convicted of violating this law and appealed on the grounds that the statute violated the First Amendment, basically. So the question was, did Schenck's conviction under the Espionage Acts for criticizing the draft violate his First Amendment right to freedom of speech? The court actually rules against Schenck here, and this is an example of them limiting free speech, of them basically not expanding civil liberties, but limiting speech, specifically if it relates to potential dangers that could come about of the speech. So the court held that the Espionage Act did not violate the First Amendment, and it was an appropriate exercise of Congress's wartime authority. And this was a unanimous decision. This is right after the war, so you still have this mindset. And oftentimes in wartime, we see the justices rule in favor of government authority versus individual freedoms. For me personally, I don't agree with this decision. I think that Schenck, although he was doing something that the government didn't like, I don't think he was doing anything that created a clear and present danger by passing out leaflets. So I disagree with this case. I think that Schenck should have been able to, pass out those pamphlets. But again, I'm not living in 1919 post World War I, so maybe I'd have a different view if I was, of the era. But I think the reason why this was chosen as a Supreme Court case by the curriculum board is because it's an example of limiting free speech, even though this case doesn't even really apply to case law today. There's actually later cases that have come and been more specific, and basically that if speech creates imminent lawless action, then it can be regulated. Clear and present danger is a little vague language, so the court went up and cleaned that up later on in later cases. Okay, so great video on Schenck from the Bill of Rights Institute. Check it out. Okay, we're on to our next enduring understanding. Protections of the Bill of Rights have been selectively incorporated by way of the 14th Amendment's Due Process Clause to prevent state infringement of basic liberties. We got 3 cases that relate to this, basically, of this idea of selective incorporation. So what is selective incorporation? Let's define that real quick. Incorporation is applying the Bill of Rights to the states, and we call it selective incorporation because it's been done so on a piecemeal or a case-by-case basis. So now today in 2021, most of the rights in the Bill of Rights have been applied to the states, but it's still been a case-by-case basis, hence the word selective incorporation. We'll look at Gideon v. Wainwright, we'll look at Roe v. Wade, and also McDonald v. Chicago. Okay, so Gideon v. Wainwright. Oh, Gideon's one of my favorite people. This guaranteed the right to an attorney for the poor or indigent in a state felony case. So who was Gideon? Gideon was basically a man that was charged in Florida State Court with felony breaking and entering. But when he appeared in court without a lawyer, he requested that the judge appoint one for him. But under Florida state law at the time, only an attorney could be appointed in a capital case, basically a murder trial. Then they would get an attorney. But because this was just a petty larceny or a felony, that was not going to be the case. So he represented himself as best he could in trial, but he was still found guilty and sentenced to 5 years in prison. And so Gideon's one of my favorite people because he spent his time in prison trying to challenge his conviction, but then also give rights to other people as well. He filed a petition of habeas corpus to the Florida Supreme Court, arguing that the trial court's decision violated his constitutional right to be represented by counsel. Because there is something in the 6th Amendment that says that you have a right to counsel. The problem for Gideon is that that right was not incorporated yet. So if Gideon was in federal court, he would have been given a lawyer. But because he was in state court, the states were not required at that time to provide one. So the question is, does the 6th Amendment's right to counsel in criminal cases extend to felony defendants in state courts? And the Supreme Court ruled yes in favor of Gideon. They said the 6th Amendment's guarantee of a right to assistance of counsel applies to criminal defendants in states by way of the 14th Amendment. So the language in the 14th Amendment puts restrictions on states and requires states to honor due process and citizenship and equal protection. So through that due process clause in the 14th Amendment, that's how we've selectively incorporated. And so now, thanks to Gideon, if you're in state court or federal court, as you always were, you will be given a lawyer if you're not able to afford one, basically. Okay, Roe v. Wade extended the right of privacy to a woman's decision to have an abortion. So Jane Roe was actually a fictional name used in court documents to protect the plaintiff's identity. But that person filed a lawsuit against Henry Wade, the district attorney of Dallas County, Texas, where she resided, challenging a Texas law making abortion illegal, except by a doctor's orders to save a woman's life. So at the time, Texas had a ban on abortion at any time, basically. So in her lawsuit, Roe alleged that the state laws were unconstitutionally vague and abridged her right of personal privacy protected by the First, Fourth, Fifth, Ninth, and 14th Amendments. So the question is, does the Constitution recognize a woman's right to terminate her pregnancy by abortion? And what the Supreme Court did is they didn't establish the right to privacy. That was actually established in a previous court case. Griswold v. Connecticut was a case that dealt with birth control. But where does that right to privacy comes from? Because it's not in the Constitution, basically. So where do we get this right to privacy? Well, there's protections in the First, Fourth, Fifth, Ninth Amendments that basically protect privacy in a way, right? Your First Amendment rights that you're able to basically speak how you feel or not share how you feel on something. Same thing with the Fourth Amendment, the right to be secure in your homes. With the Fifth Amendment, you don't have the right to not incriminate yourself. And then the Ninth Amendment, remember, just says just because these rights are listed doesn't mean they're an exclusive list. And through the 14th Amendment, this should be extended to a woman's right to have an abortion, basically. So inherent in due process clause of the 14th Amendment is a fundamental right to privacy that protects a woman's choice whether to have an abortion. However, this right is balanced with government's interest in protecting women's health and protecting human life. So the Texas law challenged in this case violated this right, basically. So they did put limits and they did put instances about when it would be okay for states to do so. But basically, in the first trimester, the first 3 months of a pregnancy, states are not allowed to specifically have a law that bans abortion, basically. They can put restrictions on it, and lots of states have moved to do that, especially because a lot of conservatives don't like this decision. Remember, conservatives tend to be pro-life. So a lot of conservatives feel like this case was wrongly decided, and they feel that that they should protect the health of the fetus and not the right to privacy of the woman who's having the child. So very controversial case. You're never going to be expected to share your feelings on abortion. That won't be where this case will relate to. So keep that in mind. So we all have our own personal opinions on that issue. It's very controversial. I would just say respect and listen to the opinions of others on this and try to learn from people. Okay, so Roe v. Wade from the Bill of Rights Institute. You can check that out. It's a really good just overview of that case. Let's go into McDonald v. Chicago. So my writing for this one is Old MacDonald wanted a gun, but Chicago told him no. All right, I crack myself up. Anyways, this is basically incorporated the Second Amendment right to keep and bear arms for self-defense is applicable to the states. To be honest, when the curriculum board released the 15 cases, I had not heard of McDonald v. Chicago. And at first I was like, I didn't learn this in college. Well, I graduated college in 2006, so that's why it was never taught to me. But anyways, I looked up this case and I go, oh, immediately I know why they chose it. They wanted an example of selective incorporation. So several suits were filed against Chicago and Oak Park in Illinois challenging their gun bans after the Supreme Court issued an opinion in District of Columbia v. Heller. And the plaintiffs basically argued that the Second Amendment should apply to state and local governments as well. So this was an attempt to incorporate or apply that Second Amendment right to keep and bear arms to state and local governments. So the issue was, does the Second Amendment apply to states because it is incorporated by the 14th Amendment's privilege and immunities or due process clauses and thereby made applicable to the state? And the Supreme Court actually reversed the lower court. They reversed the appellate court, holding that the 14th Amendment does make the Second Amendment right to keep and bear arms for the purpose of self-defense applicable to the states. So they basically said Chicago's actions to try to prevent Otis McDonald was his name, from owning a gun for self-defense, they basically said that was unconstitutional. Okay, so now the Second Amendment right to keep and bear arms is applicable to the states by way of the 14th Amendment. So it's another example of selective incorporation. And check out the Bill of Rights Institute on McDonald v. Chicago. Okay, we're getting there. I'm so proud of you. You're still watching this with me. Cheers to you. That's awesome. Enduring understanding, the 14th Amendment's Equal Protection Clause, as well as other constitutional provisions, have often been used to support the advancement of equality. So we've got one case that relates to the 14th Amendment and equal protection, and that's Brown versus Board of Education, which basically said that race-based school segregation violates the Equal Protection Clause. So this case, so Brown was actually a collection. It was 5 separate cases, and the NAACP worked to help those families to sue, basically challenging the segregation laws and rules in their counties and states. So in each of the cases, African American students have been denied admittance to certain public schools based on laws allowing public education to be segregated by race. So at this time, when this case was decided, you had white schools and you had black schools, basically. And while in theory they should have been equal, because that's what separate but equal was supposed to be, they weren't actually equal. So they argued that such segregation violated the Equal Protection Clause of the 14th Amendment. The plaintiffs were denied relief in the lower courts based on existing precedent under a case called Plessy v. Ferguson, which was a case back in the 1890s that dealt with basically upholding segregation. And it set that precedent of separation is okay as long as it's equal. So it established that separate but equal, precedent, which held, basically said that these racially segregated public facilities were legal as long as that blacks and whites were equal. And that was known as that separate but equal doctrine. But why this was challenged is because that was, in theory, they were supposed to be equal, but in practice, there was nothing equal about the black schools and the white schools, basically. So does the segregation of public education based solely on race violate the Equal Protection Clause of the 14th Amendment? And the Supreme Court said yes, that separate but equal educational facilities for racial minorities is inherently unequal, and it violates the Equal Protection Clause of the 14th Amendment. Chief Justice Earl Warren, this case is pretty amazing if you ever try to understand the history around this case, because actually it looked like it was going to be 5-4 against Brown, but the Chief Justice at the time died while the case was still being decided and argued. And so the new Chief Justice that was appointed by Eisenhower actually became the 5th vote for Brown and convinced the other 4 justices to make it a unanimous decision. So was able to use politics to get the other justices to go along with this, to give it more weight, basically. They said that separate but equal facilities are inherently unequal and violates the Equal Protection Clause of the 14th Amendment. So segregation of schools is not constitutional, basically. You can't have schools separated by race. Okay, enduring understanding, we're looking at the impact of federal policies on campaigning and electoral rules. Continues to be contested by both sides of the political spectrum. One case on this is our only case relating to campaign finance. There is a context clue because you got FEC, Federal Election Commission. It's Citizens United versus the Federal Election Commission. This case ruled basically that political spending by corporations, associations, and labor unions is a form of protected speech under the First Amendment. So basically this starts with a law called the Bipartisan Campaign Reform Act, which is an attempt to limit soft money and limit kind of the untracked money that's in politics. And also was attempts to get candidates to stand by their ads. And that's why at the end of ads now you'll hear, I'm blank and I approve this message. That's federal law that requires that. So Citizens United sought an injunction against the FEC in the United States District Court to prevent the application of the BCRA, the Bipartisan Campaign Reform Act. They published a movie called Hillary the Movie, which was very negative, a really negative kind of hit piece on Hillary Clinton. And basically they felt like that they should be allowed to air it to educate people about her as a candidate. But the movie expressed opinions about whether, and she was a senator at the time, whether Senator Hillary Rodham Clinton would make a good president. In an attempt to regulate big money campaign contributions, the BCRA applies a variety of restrictions to what we call electioneering communications. So the BCRA was intended to limit this kind of electioneering and try to limit the money in politics, basically. So there's a couple issues that the court looked at. First, did the Supreme Court decision in McConnell resolve all constitutional as applied challenges to the BCRA when it upheld the disclosure requirements? So in a previous case, the Supreme Court actually upheld the BCRA. Is that still applied, basically? And then do the BCRA's disclosure requirements impose an unconstitutional burden when applied to actual electioneering requirements because they're protected political speech and not subject to regulation as campaign speech? And then if a communication lacks a clear plea to vote for or against a particular candidate, is it subject to regulation under the BCRA? And then lastly, should a feature-length documentary about a candidate I lost my place, about a candidate or for political office be treated like advertisements at issue and in the McConnell case, and therefore be subject to regulation under the BCRA? Okay, that's a lot. But basically, is it okay for the federal government to limit electioneering? That's basically what the question was. And the Supreme Court said, no, no, yes, yes. They overruled one of their own cases, one of the portions of McConnell versus the FEC. In prior cases, the court had held that political speech may be banned on the speaker's corporate identity, but by a vote of 5-4 on highly ideological lines, the majority did hold that First Amendment corporate funding of independent political broadcasts in a candidate elections cannot be limited. So what was the result of this case is we saw massive PACs being created, super PACs were formed after this, because you were allowed to basically advertise however you wanted to for a candidate as long as your organization wasn't directly tied to the candidate, basically. So I really recommend you watch the video on this one. This is kind of a complicated case involving campaign finance, but basically, and there's different ideologies, some people feel like this was wrongly decided and it gives corporations and unions and organizations too much influence in our government. And other people say that those organizations should have First Amendment free speech protection. So really depends on where you sit on the ideological spectrum on how you view this case. Check out the video on this one, though. I highly recommend it. It's really well done. Thank you, Bill of Rights Institute. Okay, 2 more cases. We're almost done. I'm so proud of you. If you've made it this far, you can stick with me for 2 more. So the Republican ideal in the U.S. is manifested in the structure and operation of the legislative branch. So both of these cases relate to the legislative branch. They really relate to the issue of redistricting and gerrymandering. So Baker v. Carr, this case is important for 2 reasons. One, it upheld this one person, one vote doctrine, but it also opened the door to equal protection challenges to redistricting and the development of that basically doctrine by saying that challenges did not raise political questions that would keep the federal courts from reviewing such challenges. For example, before the Supreme Court really wouldn't touch cases that involved elections or redistricting because they felt like those were political questions. But the court in this case ruled that actually it's an equal protection issue that the court can resolve. We're not trying to decide who should win elections. We're just trying to make sure that people are equally represented and protected. So basically what happened is that in Tennessee, Charles Baker and other Tennessee citizens said that this law that was written in 1901 to apportion the seats was virtually ignored. And so they had population shifts and changes in their state, yet they were not changing and redistricting, basically. And so you had one legislator that was representing a massive number of people and another legislator that wasn't representing that many people. And so that's not fair to the citizens, basically. The issue was, did the Supreme Court have jurisdiction over cases of legislative apportionment? In an opinion, we explored the nature of political questions and, like we said, opened the door to these challenges and appropriateness of court action on them. The court held that there were no such questions to be answered in this case, and that the legislative apportionment was a justiciable issue. It was something that they had the authority to rule on. And in the majority of the opinion that Justice Brennan provided past examples in which the court had intervened to correct constitutional violations, and basically said that, it's our job to protect equal protection, to make sure people are treated equally in their states. And by Tennessee not redistricting, by having, districts that varied widely in size, that they were violating equal protection, basically. So now the courts have said basically that districts have to be roughly equal in size, basically. You can't have one district that has twice the amount of people as another district, because that's not fair and that's not proper representation, the courts rule, basically. A great Bill of Rights Institute on Baker v. Carr. Check out all these videos. They're really awesome. They're really short, too. Most of them are under 4 minutes, and they do just really give you quick overviews of what you need to know. Okay, 1 more left. We're almost there. Let's do it. Shaw v. Reno said that majority-minority districts created under the Voting Rights Act of 1965 may be constitutionally challenged by voters if race is the only factor used in creating a district. So what are the facts around this case? Basically, the U.S. Attorney General rejected a North Carolina congressional reapportionment plan because the plan created only one black majority district. North Carolina submitted a second plan in creating 2 majority black districts, basically. So they gerrymandered, I shouldn't say gerrymandering, they redistricted, because gerrymandering is about political parties. This is more centered around race, basically. But basically, North Carolina had a large population, a larger population of African Americans in their state, but yet had no representation. So this was an attempt to try to create a district that had a majority of Black people in it so that then they could choose either a Black representative or someone that would represent the Black community basically in their interests. So one of these districts was really no wider than an interstate road along which it was stretched. That's the top purple one if you see. And 5 North Carolina residents challenged the constitutionality of this unusually shaped district, alleging that its only purpose was to secure the election of additional Black representatives. So now this is an instance of them gerrymandering for a race, to help a race, basically. But then you had these white voters that challenged this, and they said that that's a violation of our equal protection. It's a form of reverse discrimination. So the issue was, did the North Carolina's residents claim that the state created a racially gerrymandering district? Did it raise valid constitutional issue under the 14th Amendment's Equal Protection Clause? And the court said yes. The court that held that although North Carolina's reapportion plan was racially neutral on its face, the resulting district was bizarre enough to suggest that it constituted an effort to separate into districts based on race. And so basically this case ruled that, it was already illegal to gerrymander it to hurt a race, to draw a district that was going to limit or suppress minority voting or minority representation. But in this case, they also gave that this is an example of the courts saying that also you can't gerrymander to help a race, to try to get a certain race more of a majority in a district so that they could elect someone to represent them, basically. Now, this is a really great example, and I know why they chose this case, because, again, they want examples of each. And so, example of a time when the courts expanded minority rights. So Brown versus Board of Education, they expanded minority rights by saying segregation was unconstitutional. This is an example of the federal government limiting minority rights, basically, by saying that they couldn't create a district that would benefit their minority because that would violate equal protection. So there's cases, there's questions around that as far as, should our Constitution be colorblind, or should we recognize that there's, institutional practices that were put into place that suppressed vote or that hurt races, and that is it okay for us to create programs to support those, affirmative action programs and other things like that. So this is an example of the federal government limiting minority rights, basically. Okay, check out the video on Shaw v. Reno, and I believe that's it. I didn't even come within the end slide. What? That's unfortunate, but we are at the end. So I appreciate you. You made it through. Oh my gosh, 47 minutes. I can't believe that you're still here. Hopefully you watched this in chunks. You didn't watch it all at once. Okay, I'm tired and I have a meeting I need to get to, actually. That's starting soon. So cheers to you. Thank you for being here. Make sure that if you have questions on these cases that you email me, that you ask me, all 15. You do need to know the facts around them, the cases the constitutional issues that they address, and why they're significant, basically. So if you have questions, please don't hesitate to reach out. I'm here to support you. Most importantly, we need to keep calm and Viking on.